Steph is co-founder of Fair Go for Queensland Women and has undertaken graduate study in developmental trauma as well as domestic and family violence. She has an ongoing interest in research in this area. Steph has a particular interest in the damaging effects on women in prison who are forced to be housed with trans-identified men. She's a mother to 2 sons, and the title of her presentation is The Impact of Sex Self-Identification on Women in Prisons and on Crime Statistics. Thank you, Steph.
Good afternoon, everyone. It's so nice to see you all. See some familiar faces and some new ones too. Thank you all for your... Oh, the mic. Up, down. Thank you. There we go. Thank you. Can you hear me now? Yeah.
No, a little closer.
Is that any better? Oh God, someone keeps saying no. Hello.
Really close. Straight on.
Okay. Good afternoon. Oh. Good afternoon, and thank you all for your interest in today's meeting. It's so nice to see you all here. I'm going to demonstrate that DJAG, Department of Justice and Attorney General, already know self-ID is unworkable and unsafe for women and girls in general, but women in prison in particular. First of all, is that right? Yeah. First of all, I will demonstrate how DJAG already knows self-ID poses a risk to incarcerated women. Secondly and simply, humans cannot change sex. Our birth certificates record sex, not gender identity. Similarly, prison allocation needs to remain based on sex because of the persistence of male pattern violence and on the grounds of retaining women's safety, dignity and privacy. We already have mechanisms in place to keep males out of female prison estates, yet those means are being ignored both here in Queensland and everywhere where self-ID is in place, to the detriment of incarcerated women. Please note that today's discussion is going to have some talk of sexual and other violence, so please take care of yourself and reach out for support if you need. In June this year, DJAG staff spoke to myself and some women from Fair Go for Queensland Women and in IWD Brisbane Meanjin about their intended self-ID legislation. In the few minutes we had at the end, after being spoken at for 45 minutes, we asked, how will self-ID be operationalised by other departments and services? How will the needs of all Queenslanders be upheld? We were told that's not a concern for DJ, they just need to write the legislation. Everyone else will have to work it out later. To be blunt, I submit that this is unacceptable and a failure of due process and due diligence. If the government seeks to institute new legislation that will impact upon the community, they must be able to show how it will work for all Queenslanders in an impartial manner and demonstrate how they arrived at their conclusion. Despite that, if we are to take this public servant at their word and the department truly doesn't need to consider how self-ID might work in practice for other departments and services, we shall look directly then at what DJ already knows. And I contend the department knows full well that self-ID is not workable or safe, and persisting as they are in this manner is pure bloody mindedness. In 2013, a man attempted to enter a number of homes with a view to stealing belongings from those homes. Upon entering one, the man came across across a woman asleep, pinned her to the bed with his thighs, covered her mouth with his hand and used the other to touch her genitals outside of her clothes. The woman's daughter awoke upon hearing the struggle when the woman scratched the man on the face, or I think it's the face, and they fell to the floor, whereupon the man slammed the woman's head into the ground more than once. When he saw the daughter, he left through a window. The offender was convicted of sexual assault and other offences in August 2013. Further offences and behaviours of concern undertaken by the detainee while in the male prison estate include entering the officer station in October 2014 and pressing his erect penis against a female correctional officer's arm, as well as masturbating in front of a female chaplain. Due to the ongoing behaviour of the prisoner and their assessment of the risk he would pose in the community, DJ made application to have him considered for an order relating to serious or violent offenders or dangerous sexual offenders. The application was ultimately dismissed. This person was interviewed and assessed by no less than 3 psychiatrists. We are not told when the individual began identifying as transgender, but we do know that the assessments occurred in 2021 and 22. Not one of the reports by those 3 independent psychiatrists appears to have referred to the individual as transgender, as all quotes from the reports have the pronouns altered to say that this man is a she. This makes for disconcerting reading and begs the question, when was the claim of transgender identity made, and why does the court see fit to alter the reports made by others? Indeed, one of the experts even told the court that they do not consider the claimed transgender identity to be factual. Now, I would ask, if we are going to proceed with a system of self-identification and the Supreme Court and DJ will not respect the assessment of a psychiatrist over the proclamation of an individual, even before we have self-ID legislation, what use is there for disincentives to lie in a self-declaration? Even if such a thing was possible when gender identity is even such a thing possible when gender identity is wholly and solely within inside the head of the individual? Is this any way to govern a state? Thank you. I put it to you that this proves self-identification is unworkable for the community and also means that self-ID is not in the interests of so-called trans community either, as predators will use this loophole and cause harm in their name. It gets better, or worse, as the case may be. As it happens, this individual, who DJ assessed to be a risk in the community for offences such as unwanted touching, flashing and other sexual offences, likely linked to his impulsivity, was rearrested barely a month later on other charges that could be seen as callous, impulsive and opportunistic. The media reports all refer to this individual as a man. There is no reference whatsoever to this person claiming to be transgender. So this proves again that this legislation, the proposed legislation, is faulty and not in the public interest. This person has claimed a transgender identity when arguably they may have thought they would seek some benefit from doing so. But the moment it was not needed, it was shared. As identified on the screen, this has been identified as a problem in other jurisdictions too. One might say, well, if he's rearrested and detained, then there are risk assessment procedures in place, even if he does claim to be transgender again. Well, we have already seen how that has worked out. Lisa Jones, a convicted sex offender who identifies as transgender, housed in the Dame Phyllis Frost Centre in Victoria. The state, DJ, told us they wish to emulate. Jones was deported from Germany after spending time in prison in relation to sexual offending against a female child. In Victoria, Jones attempted to rape a woman and was reported in the media as both a woman and female. Despite this, he is currently housed in a female prison. I put it to you that the risk assessment procedures that are spoken about do not in any way attend to the needs of incarcerated women, and we should be highly dubious of any claims to the contrary. To be very clear, DJ knows very well about the individual I've recently spoken about, and as such, they know about these risks of self-identification. The very fact that this person was arrested again within days of release and now appears quite content to be referred to as a man suggests that the claim of transgender status may have been used to seek leniency in the courts. Some final thoughts on this individual and the blatant unsuitability of self-ID. If this male made other males deeply uncomfortable due to his overtly sexualised behaviour while in the male prison estate, what might be expected or predicted to occur if he were to be detained in the female prison estate? This person is reported in court documents to have limited impulse control, and if given access and opportunity, may very well commit sexual offences against women. It is in this way that self-ID legislation could create a situation where a man harms a woman or girl in a women-only space and is then placed in a female prison estate with vulnerable women who cannot escape. Perversely, due to the same collective madness, a woman who objects to this could also be placed in prison with that man. One might say, well, Steph, it's only one person, and yes, that's true, but the bottom line is, this man is male, and this is about male pattern violence and male criminality. The graph up on the screen right now talks to the number of males versus females in the Queensland prison estate on the 30th of June each year from 2013 to 16. You can see the vast difference between males and females. But also, the number of men who say they are women in Queensland prisons compared to women who say they are men is also explanatory. This is about male pattern criminality. Sex matters. In 2017, in Queensland prisons, there were almost as many male prisoners who claimed to be transgender with the most serious charge or conviction of aggravated sexual assault as there were females for the same charge or conviction. So, as Deb said, just take a moment to take that in. Out of all the women in Queensland, there were 698 women in prison on the 30th of June 2017. Of those 698, 9 women were in prison in response to a most serious charge or conviction of aggravated sexual assault. That's about, or just over, 1% of the entire female prison population. Now, consider the allegedly tiny, vulnerable and oppressed transgender community. In that same year, over 25% of the population of men who say they are women were housed in prison for that same charge or conviction. This is not comparative. This is the difference between male and female criminality. This does not suggest that men who say they are women are actually similar to women in terms of their propensity to commit sexual violence. And it needs to be talked about. What happens to our data on sexual violence when these offences are recorded as being committed by women? We simply cannot remove our ability to accurately record and analyse male violence. We simply cannot have a situation where women are being held responsible for male perpetrated crimes. I submit it is dangerous and neglectful for anyone to subject incarcerated women to this level of risk and unnecessary trauma. We know that males present a significant risk to women in the prison environment. In times of war, we have the Geneva Convention, which sets out that males and females must be housed separately. Australia is party to that UN instrument. In civilian spaces, we have the Mandela Rules, which holds there are different categories of prisoner and they must be housed separately. Those categories include youth versus adult and men versus women. As the Mandela Rules were first written in the 50s, it's quite safe to say that this refers to men as adult human males and women as adult human females. Make no mistake, to enable males to be housed in the female prison estate, one must dutifully ignore the entirely predictable outcomes such policies will create, and similarly, completely ignore the examples of when these very things have already occurred. It too requires the elevation of the Yogyakarta principles over the far more established Mandela Rules. We have been aware for quite some time that the women who are incarcerated in our prisons are likely to be women who have considerable experiences related to trauma linked to male violence. We have decades of documentation of male violence and female victimisation, and how incarcerated women are highly likely to have significant trauma histories. This includes reports by the Queensland Human Rights Commission, who used the Mandela Rules as a basis from which to analyse the treatment of Queensland women in prison, right up until the point of when they want to talk about males in prison, and then they switch to the Yogyakarta principles. It's like reading an article on evolution, but then having a paragraph in the middle talking about Adam and Eve. And why? To attend to the interests of males who identify as women over the well-established and hard-fought-for rights of women. It is, she's that bell. It is, to my mind, the epitome of male entitlement and self-interest that long-established sex-based rights of women are completely forgotten when a man comes along and wants to encroach on our spaces and violate boundaries. And then to also brand those of us who raise this issue as TERFs, bigots, and other such smears. As others have talked about today, what you can do: talk, write, speak to others about what's going on. Remind your local member that women exist and we have protections in law. Ask, where is the polling to show that Queenslanders are on board with this and that they understand what the implications are? Do the legislators who are writing this legislation understand what the implications are? Where's the evidence of broad consultation? And finally, before she rings the bell again, self-ID cannot progress in the way that it has in other jurisdictions. There must remain clear ways to delineate and record sex, and the two, sex and gender identity, cannot be conflated. Sex matters in many areas of life, and the status and well-being of women and girls relies upon this being recognised. Incarcerated women's needs for safety, privacy and dignity must not be ignored in favour of subjective notions of gender.
Thank you.